we would like to start. On behalf of USIP and the Latin American program, it is a pleasure to welcome all of you to this private roundtable, in which we have the honor to have two very distinguished guests. The President of the Special Jurisdiction for Peace, Magistrate Roberto Vidal, and Ambassador Beth Van Schaak, Ambassador at Large for Global Criminal Justice at the State Department. They will be discussing Colombia's groundbreaking contribution to transitional justice while navigating the tensions and complementarities of both restorative and retributive approaches. It is important to highlight that the Colombian transitional justice process has made its main objective to put the victims of the armed conflict at the forefront of this restorative process in Colombia, giving them a voice and a role focused on obtaining truth, justice, reparation, and non-repetition. Afterwards, we will have USIP's transitional justice expert, Carl Stoffer, and Auxiliary Magistrate Ana Maria Mondragon from the JEP, who will provide some brief comments and reactions on the fireside chat between Ambassador Van Schaak and Magistrate Vidal. And then we will provide space for questions and answers from the public. But first, please, Steve Hagee, who is our Regional Director from the office in Colombia, will have some remarks.
Thanks so much, Lucy. Good morning, everyone. It's a great pleasure, as Lucy mentioned, on behalf of USIP and the Latin America Center to welcome you all this morning for this timely and what we honestly feel is a truly important conversation about the Special Jurisdiction for Peace's groundbreaking efforts, trying to balance, as we put in the title of the event, the retributive, punitive aspects of the 2016 Peace Accord with its restorative spirit. In addressing egregious war crimes and the damage and harm that they've caused to Colombian society. We're very elated, as Lucy mentioned, to have Magistrate Roberto Vidal and Ana Maria Mondragon visit us again to our headquarters here in Washington. They're always welcome here. This is their home, and we really appreciate their interest in being here and participating in this conversation. It's really been an honor as our country director in Bogota for USIP to work closely with the JEP, to learn from the JEP, to accompany certain processes, including part of the reason we're having this discussion here today about the manual. So it's been an honor. Thank you very much for allowing us to be along your side in this journey. It is with equal pleasure that we also welcome Ambassador Beth Van Schaak, whose leadership over the U.S.'s response to accountability for war crimes across the globe has truly been inspiring. And I think on behalf, in the case of Colombia, on behalf of the JEP's many strong allies, I think we all want to express a note of gratitude for Ambassador Van Schaak's vocal and public endorsement of the JEP, really through her May 2023 visit to Colombia. Following several years of ambiguity about the relationship between the United States and the JEP, it was really galvanizing for the JEP and its staff and all those stakeholders contributing to hear and understand that the U.S. was indeed a champion for the JEP. Her announcement of sanctions against individuals who have sought to undermine the JEP sent a strong message to Colombian society that the U.S. stands firmly with the deeply challenging but necessary commitment to restorative justice. We couldn't imagine a more well-suited guest, co-participant in this fireside chat this morning than Ambassador Van Schaak, and really thank her for accepting this invitation. As I said, the main reason that we have as an impetus for this event today is the celebration of the launch of this manual of transitional restorative justice, which is just hot off the press with this beautiful front cover, but will be formally printed and distributed in the coming weeks, both in Spanish and English. For anyone that's interested, we have a few copies here, very limited. But we will have those available, as well as anyone who would like to read the English version of that manual. Please see me afterwards, and I'll be able to get you the electronic version of the English version. The manual itself has really been the culmination of years of effort from many magistrates and senior advisors of the jurisdiction. I want to acknowledge in particular Ariel Sanchez and his leadership within these efforts. But the manual, more than anything, embodies Magistrate Vidal's vision for the JEP, and is really one of the cornerstone of his many footprints of the legacy of his presidency of the JEP, and this really culminates so much of his efforts to ensure that the restorative justice is defined more clearly and strengthened in its spirit within the jurisdiction. I want to express a particular note of gratitude to someone who's not here today, who's joining us virtually, my colleague Gabriel Rojas, our USIP Director for Restorative Justice from our Bogota office, who worked exhausting hours to support the JEP in developing the manual to consolidate hundreds of comments with Ana Maria and many others, comments and feedback from key stakeholders and magistrates across the court. As USIP, we're really honored to have this opportunity to support the manual through Gabriel's leadership, and unfortunately Gabriel was not able to join us today as his visa was not renewed to come here to the United States, but he joins us virtually along with other colleagues from our Bogota office. While the restorative aspect of the 2016 peace accord really emerged as a solution to, as Magistrate Vidal has pointed out many times, a real political conundrum in the peace negotiations, in that armed groups don't often negotiate their own imprisonment, there had to be some other solution. But what emerged as a solution of embracing restorative justice has allowed for the court to innovate in, I think, really many groundbreaking ways. The manual consolidates jurisprudence, methodology, and learning of the JEP over its more than 6 years of operations, and it serves to strengthen and deepen the restorative processes in the implementation of crucial sentencing for perpetrators, which is just beginning this year. I just want to lay out very briefly the seven pillars of restorative justice that the manual outlines. The first being reconciliation and peace above all. Second, participation by victims, perpetrators, and communities. Third, the recognition of responsibilities. Fourth, reintegration of perpetrators into civilian life. 5, progressiveness and preparation. And 6, differentiated perspectives of intersectionality with a territorial focus. And finally, the 7th pillar approach geared towards repairing collective harms. And all this is proposed to a Colombian society which is still very deeply retributive and punitive in the way that it looks and approaches justice, even many of the strongest voices of its own human rights community. The manual, however, helps redefine what is truly punitive. As we can attest to as USIP and many in the JEP, there's been countless cases where the discomfort and the constructive shame of having to engage with victims over a sustained dialogue process has been much more transformative and frankly difficult for perpetrators than passively letting the years go by in prison sentences. As Ambassador Van Schaack, however, can attest, the restorative approach in transitional justice frameworks is quite rare in the international community. And there's a broad consensus, largely that the focus should be geared around pursuing punitive imprisonment for perpetrators with lengthy sentences which are commensurate with the gravity of their crimes. However, restorative justice asks a different set of questions, not obsessed with the proportionality of prison sentences, but with what truly can repair social fabric and collective harm caused by war crimes. And that the JEP has shown that the satisfaction of victims receive from proactively engaging with perpetrators in meaningful dialogue process is much more transformative and deeper than simply receiving passive truth-telling in a one-direction fashion. They get to grapple with the nebulous and lingering why of their suffering, the why of the crimes that were perpetrated against them. And as Carl Stauffer, our illustrious restorative justice expert here and esteemed colleague, has always pointed out to us, that restorative justice really places the focus on the needs and dignity of both victims and extends that to perpetrators themselves, calling on them to transform their contributions to society to become peace builders. So this is really the legacy of this manual, the legacy of the JEP's work for global practice in transitional justice. And it's not stopped. I hope that Roberto will also share during the fireside chat some questions, reflections about what this means for Colombia beyond the JEP, the learning of the JEP for the current peace negotiations that are ongoing with several other armed groups, including FARC dissidents and the National Liberation Army of the ELN. And how to incorporate restorative principles, aspirations into the ordinary criminal justice system, which is a key aspiration of the current Minister of Justice. So with that, I want to thank all of you for attending this morning, those who are connecting virtually, and in particular, Magistrate Vidal and Ambassador Van Schaack. Thank you very much for being a part of this conversation.
Thank you, Steve, for this very thorough framing. So we can start our fireside chat with, please, I would like to ask Magistrado Roberto Vidal, if you can come to the stage, as well as Ambassador Manshak. And I will just mention a brief bio of each one of them. Magistrate Roberto Vidal was elected in October of 2022 as President of the Special Jurisdiction of Peace for a period of 2 years until 2024. Previously, he served as magistrate at la sección de primaria instancia en casos de reconocimiento de verdad y responsabilidad of the Special Jurisdiction of Peace. Of course, he's a lawyer from la Universidad Javeriana de Colombia, as well as he holds a JD from the same university. And he is an expert researcher in human rights, international humanitarian law, forced migration, international displacement. As well, he has worked with several organizations in Colombia, as well as here in the US. Dr. Beth Van Schack is Ambassador at Large for Global Criminal Justice at the State Department. In this role, she advises the Secretary of State and other department leadership on issues related to the prevention of and response to atrocity crimes, including war crimes, crimes against humanity, and genocide. In her long professional and academic career on the defense of grave and serious violation to human rights, I would like to just pinpoint that she has served as academic advisor to the U.S. Interagency Delegation to the ICC Review Conference in Kampala, Uganda, and worked at the Office of the Prosecutor of the International Criminal Tribunals for Rwanda and former Yugoslavia in The Hague. So you will have 45 minutes to chat, and please, the floor is yours.
Thank you. Well, thank you for that warm welcome. Oh, yes. It's really lovely to be here. I think I speak for both of us when I say we're thrilled to be able to reconnect. We've had a number of opportunities to appear together. And I guess I want to thank USIP, Steve, Lucy, everyone, Carl, for hosting us, for everyone for attending, and you, Roberto, for your just exceptional leadership of the JEP. It's been amazing to see what that institution and the whole system has been able to accomplish under your leadership. So thank you. Thank you. Great. So maybe I'll. Do you want to say a few words?
No, yeah. I want to thank, of course, to you first of all. It's a long and extraordinary work together. Thank you very much. To the Institute for Peace, thank you for the invitation, for the support. You have a strong work in the manual, and it is a product of our work together. Thank you very much for that, and all of you for the interest in the process of peace in Colombia, and to support these efforts of our country. Yeah.
It really is a remarkable system, and I think Colombia has been the first to be very self-conscious and deliberate about balancing the retributive elements of transitional justice with the restorative ones. And I think it will be a model, and I can just share a quick anecdote. I was in Ethiopia about 8 months or so ago and was meeting with very senior members of the Ministry of Justice, Ministry of Foreign Affairs. They are in the process of crafting a transitional justice response, not just for the war in Tigray, but for violence more broadly. It's been nationwide, and it's a huge country like Colombia. And the Deputy Minister of Foreign Affairs walked into a meeting carrying a book on Colombia's transitional justice system. They were very clearly trying to learn from this approach and think about how to adapt it for their own purposes. And what always strikes me, and what we've tried to do with our diplomacy and our programming, we have a small project with American University. It's great to see Natalie here representing that project to help enable the JEP to do its work in the most victim-centered way, to make sure that historically underrepresented communities have full roles, to make sure the work of the JEP is not just in Bogota, that it's out in the various areas where the violence touched so deeply. But the idea of making sure that we're investing in all sides of this institution, because it is an ecosystem. And if one side gets out of whack, the whole system is out of whack. And so the restorative side has to offer sufficient incentives for the perpetrators to come forward, but it also has to offer sufficient making of amends, sufficient taking of responsibility, so that the survivors feel like the perpetrators are not kind of getting off easy. And this is where I think your work, co-creating alternative sentences, will be so important. And I'd love to hear, and I'm sure the group would love to hear more about where that stands. And we know that upwards of 90+% of perpetrators on both sides have opted to participate genuinely, accept responsibility, speak truthfully about their own roles and responsibility in violence, and make themselves available to give back to the community and help rebuild not just communities that were harmed, but the whole body politic. And even, I'll maybe talk later about my visit up to the Sierra Nevadas of Santa Marta, where the restoration of the environment is such an important element of this. But that 5% who have opted to, roll the dice and try and fight in the retributive adversarial side, that side has to be strong as well, because if they start getting acquitted, let's say, and of course, if the evidence is appropriate for them to be acquitted, they should be acquitted, but one would hope that not all cases that go to that component of the larger system will be acquitted. That could undermine the willingness of people to submit to, as Steve describes, what can be very onerous restorative justice approaches. Having to accept responsibility, having to face the victims and the survivors and acknowledge that you were the one that took their loved one, that you were the one that issued an order to engage in falso positivos, that you were the one who insisted upon illicit monocrops destroying the environment of a community. That's very hard to do. And having spoken with some of the perpetrators, many of whom have formed organizations to support each other in this process, they will admit how horrible it was and how painful it was. And their children are experiencing, oh, your dad's a war criminal. He admitted responsibility. They're hearing that on the schoolyard. So it's a careful balance. And I know the group would be very interested in hearing more from you about how you're maintaining that balance and maybe currently how the various mechanisms and components are working together.
Well, thank you, Beth, for this very accurate introduction to the work that we do. Well, the idea of restorative justice connected with transitional justice is part of the innovations of the tribunal in Colombia and the model that the negotiations produced. And it was not easy for us to understand what it means for the kind of judicial work that we do. Of course, when we started the tribunal, we approached from the ideas of criminal justice that we have, that were very traditional. We are 38 magistrates with very different the histories of work, but all of us, we are lawyers, and it is a way of thinking on injustice and criminal justice. When we deal with the restorative component, we had to start to learn about the implications and the effects of this connection. We started working with victims, and it is the point of departure. That is we understood in a good moment that the participation of victims was the cue of the restorative process. And we started consultations, dialogues, opening the tribunal to the connection with people in territories and traveling for all the country, talking about the tribunal and the possibilities that we opened. It was not easy. In the sight of the judges, because many of our colleagues say we are a high court and a high court never goes to the territory. Yes, and from the side of the victims, they they didn't believe in the possibility of effective participation. And we start this construction and this learning. And the first result of this work was the presentation of reports by the victims. 4 years later, we had around 1,000 reports of the organizations. That is the database of our investigation. And very important because it's a description from the point of view of the victims of the worst crimes and the effects of the 50 years of conflict. Well, we started in this point, and then we have the discussion about the kind of procedure that we need to implement, because the traditional procedure where the language of the criminal law wasn't enough. Concepts like the equality of tools between the indicted and the prosecutor, it is not useful for us. And we had to deal from the beginning, from the point of view of the defendants, with the something that the concept of deterrence, that it's in the base of the criminal procedure, was not exactly the issue in a transitional process. When we started to talk with the former guerrilla men and women, they said the prison or to be killed is something that is part of the life of a guerrilla. They faced it every day, and they don't feel any deterrence, or they are not frightened with the possibility to go to prison. It is not a real tool, and it make the obligation of the judges to have a reflection on what can substitute the idea of deterrence. And we started to work in ideas of stimulus to stay in the process, to stimulus or to help the defendant to maintain their obligations, their compromises with the process. And we started to see clearly that the goal of the jurisdiction, the main goal is the non-repetition. And it's the central to what we can give to society. Not the idea of punishment of the former criminal only, but the idea of we can send to society people that is integrating, that can work, that can have a family, that can have economical, social, even political projects that construct ties between these persons that are part of the agreement and the future of the country. And it started to make sense, the idea of a restorative process or restorative procedure, that it is plenty of participation in the side of the victims and in the side of perpetrators, an idea of integration and this stimulus to push that people into the society, to inside the society, and not to put it outside. It was the starting point of the issue. And then we deal with the obligations that the procedure defined for the tribunal. That was the obligation to contribute with the truth. And it was a surprise for us too, because we understood that the truth is not only a rational decision of the perpetrator to say all the truth, We started with that. Please sit and say all the truth in this moment. It is not like that. It is a long process of construction of the truth, because we understood that the perpetrator in most of the cases doesn't understand what happened or the effects of what they did. When the perpetrator was facing the victim. And we started the restorative process of dialogues between the victims and the defendants. They started to understand what happened, to understand the pain, to understand the damage, to understand the effects, the communitarian effects of the crimes. And it produces a change, a deep change, first of all, in the victims. We very soon abandoned the idea of pardon. The pardon is something very personal and deep. And we started to work on the idea of comprehension, when the idea of respect from part of the victims. They give that as these people has a moral value, very impressive. And in the sight of the perpetrator, they started to change themselves and to understand the position of the perpetrator in the war, the effects of the war, and their own story in the war. And in the sight, finally, of the judges, we suffered changes, deep changes in our comprehension of the Colombian history. And I think that we moved to abandon the idea of good man and bad man, the evil of the perpetrator, and to understand the sad story behind any of the characters of the war, in the victims first, but in the perpetrator side too, and the community. And finally, all this process moved us to the moment of the recognition. The moment of recognition has been very strong. We discovered with the judges this idea of hearings, public, enormous hearings with defendants, with victims. When we move from the room to the internet, and then from the internet to television, it changed. It's a qualitative change in the kind of things that we were doing, and the political consciousness of society about the conflict, and it was connected with the to be aware of the necessity of the peace process. Only the people that doesn't know anything about the conflict defend the war. But when they are aware of the damage, of the suffering, they started to see the necessity of peace and the process of peace. Finally, it's a long story, but I want to put the idea of process. It's a process of learning about the conflict, about the subjects, about us. And it's the restorative component of our process has been very transformative of situation, and it is the enormous value of this experience, what I want to start saying.
No, thank you so much for laying that out so carefully. I do think that Colombia has established a new standard of what it means to be victim and survivor-centered, both from the perspective of the design of the very system, and that individuals had a say in the peace accords and what the various institutions would look like, how they would work together. In the very process of those procedures, it's not just an exquisite thing that's happening in Bogota, but it's going out into the field, it's working with individuals, hearing from individuals, the idea of acknowledgement as being a dignification of communities and survivors. And then also in the ability of survivors to co-create the remedies, what they expect. And as someone said, so I think it was you, Steve, just locking somebody up for 40 years is not going to help rebuild society necessarily. How can we think about reintegrating perpetrators, but having them support survivors? And so it'd be so interesting to hear from you about the plans for these alternative sentences. What do they look like? I know I've heard talk about trainings around exhumations, around demining, about environmental restoration after the illicit monocrops were imposed upon many of these communities, on just rebuilding the civilian infrastructure. And how do you ensure that victim communities don't feel like perpetrators are getting off too easy and they're actually benefiting from a process? We see this, I think, in some of the DDR contexts where you have demilitarization and demobilization of armed groups, and they get training, they get assets, they get land, and the survivors think to themselves, okay, great that they've laid down their arms, but why are they benefiting from a process, and why am I still suffering from the harm that those individuals cause? So how are you imagining co-creating these alternative sentences, and could you catch us up on what's been done to date?
Well, thank you, Beth, again. But this is a difficult question for the context. Mm-hmm. The first context that we face is the amount of damages that were produced under the war, and it is a demand of reparation in victims, and a reparation that in general is not possible for the state. Yeah. We have this strong dialogue with the Inter-American system, for example. That idea of integral reparation is not a real possibility in the context of massive crimes of the war. And we had an example in the first transitional tribunal that we had, that is for paramilitaries. At the moment, they have 7,000 rulings condemning the state in response for reparation of damages. And the state said, we don't have that money. We can't do anything. And it is the point of departure for this debate. Mm-hmm. When victims comes to the JEP, they have a huge expectation that we are the tribunal, that we have the answers.
Make me whole.
Yes, yeah. Yes. We have that, and we don't have that. And start a work trying to answer the demands, but in terms of the restorative process. That is different of the reparation of damage. The restorative process, and it's something that is difficult to understand, is concentrated in the reconstruction of the social fabric, the reconstruction of dignity, the reconstruction of institutions, and the position of communities, but not a direct reparation of damage. It is difficult to understand for victims, and it produces a lot of frustration about the work of the tribunal or any state institution after the conflict. Mm-hmm. And we navigate these stormy waters because it's dealing with frustration. And we are working in the idea of we don't have the possibility to offer that reparation, but we can offer participation, recognition, truth, and the possibility of connection with projects that support the victims in the process of reconstruction. But it is a very delicate line. And it conducts to the kind of projects that we are trying to construct. The first projects that we started the last week were the first one was in the mining. That is a huge problem after the conflict. The second one is environmental reconstruction in Bogotá. It's a belt of protection, of environmental protection of the city that the city is trying to construct. And the third one is memorialization with the indigenous group in Nariño. But we are trying to identify these lines of intervention that can have a restorative meaning for communities. And we learned that it's necessary, besides the process of participation, a process of communication. See, we need a strong ways of communicate and to construct the meaning. These projects need to be meaningful for victims. And this is not a fact. This is a construction. It's a work that allows us that our projects have some meaning for them. And this is the kind of negotiation that we are doing now. And it's not easy, because what is at stake is the legitimacy of the intervention of the tribunal, or the legitimacy of the state in the situation post the conflict.
Yeah, thank you so much for that. It really is true that these alternative sentences were the linchpin in many respects of that peace accord. That is what finally convinced the warring parties to be willing to lay down their arms. And so it's critical, I think, that you get this right. Great to hear that it's moving forward. I remember one of the magistrates, and your point about repair and sort of the impossibility and acknowledging the impossibility, but nonetheless still doing our best. One of the magistrates told me that she felt like her mandate was to repair that which cannot be repaired, essentially, that is what they're doing. It's an impossible task, and how difficult it is to accept a job that you know will be impossible, and yet nonetheless, every day go to work looking for ways to get closer to what you envision. And your point about participation as itself a form of restorative justice, I really saw that in Valley du Port. It was quite remarkable. So I was invited out to the Kamkwama community to attend one of the JEP meetings. And it was a very interesting hearing because it started out quite legalistic. They had done a decision, and so they wanted to read from that decision. And there was lots of citations to this and that, and I thought it was quite inaccessible to many who were in the audience, and I think I passed that feedback along to you. But then the hearing shifted, and the magistrates were able to name the names of individuals whose names had been cleared. They had been falso positivos, and if you are aware of this phenomenon, people would basically engage in social cleansing or just pick victims at random, place weapons on them or other incriminating information, and then get credit for eliminating a guerrilla. And there was huge stigma associated with being a member of the guerrilla, and yet their loved ones were killed ostensibly because they were a part of the FARC, and of course they weren't. And so when those names were read, it was remarkable. It was a huge room full of people. When the name would be read, you could tell exactly which family recognized the names, because there would be a physical, a somatic response of just relief of hearing their loved one to be cleared and to be acknowledged that they should never have been subjected to what was, in essence, an extrajudicial killing. And then people were entitled to take the floor and to describe their loved ones and what they had been doing, the life they had been trying to lead when it was stolen from them so violently. And so that notion of participation is so incredibly important. The other thing that I think you've done a remarkable job of, and maybe you can talk a little bit about that, is being inclusive. Mm-hmm. making sure that different communities, Afro-Colombianos, Colombianas, indigenous communities, women. I'm really pleased that the macro case 11 is moving forward on gender-based violence, but also focused on LGBTQI individuals, how they were specifically targeted because of their sexual orientation or gender identity. 9 million individuals have now registered as victims, and the impossibility of that. But the fact that you've been able to be inclusive, maybe you can speak a little bit about what practices you've developed in order to ensure that while not everyone will have their day in court, it is hoped that everyone will see something about the JEP process that will be about their story, and that they will feel, as you say, acknowledged. They will feel that sense of recognition and that sense of dignification.
Well, one of the contributions of the work of the tribunal to the Colombian society is a new interpretation of the kind of armed conflict that we suffer. Because the historiography of the country was familiar with the description of the conflict in terms of the Cold War, of this guerrilla in arms against a liberal state, I don't know. And when we start to, when we investigate the macro cases, remember that we don't work with case by case, but with macro cases, that is investigating patterns of the war. The kind of patterns that we find are most and most far from this idea of the political confrontations between the guerrilla and the army. And what we find is a massive and permanent attack from both sides on civil society. Mm-hmm. And it is very difficult for the country to face that reality. The idea of, for example, that this was a conflict against women. This was a country against child, against indigenous people and Afro-Colombian peoples. And they was killed, they was robbed, this was the victims of lots of crimes, and from both sides, and that in only a few in few moments the both military sides was confronted. Yes. The real practice was a permanent attack on people that was not at war, that was civilians, and it is terrible. Terrible even for the parts of for perpetrators. To say that to the army, to say you were not engaged in a huge war, you were attacking people, and to say that to a revolutionary guerrilla, to say it was not so revolutionary, the attacking women, or the sexual violence, or the recruitment of child. It is hard to find that, even for us, the investigators. And I'm talking about that because part of the contribution of our work is this new comprehension of the conflict and the situation, and it is connected with the kind of measures that we are promoting. Because we we have the consciousness that we need to work, first of all, with the groups that were the most of part of the victims, starting for women. We need to work with them. And this is what we need to change, first of all, or to work with indigenous people and Afro-Colombian peoples that have most of the effects of the war in a very unequalitarian situation with respect to the rest of the population. Or we need to work with child or with the elder. And this is the origin of this particular focus in differential programs that we are doing, not only of sanctions, but to programs of restoration with that communities. And one of the programs that we are doing is the conversation, for example, with the organizations of gender rights and defense in Colombia. And what they said us is, we need jobs, we need income, we need programs of the state, we need hospitals, we need education. And it changes the kind of projects that we have in mind. That was projects for perpetrators, not. Now we are thinking in projects where the perpetrators are working together with victims, with communities, and maybe these projects are more similar to development projects or projects of social attention from the state.
Yeah, brilliant. Well, I think we're going to open the conversation now. Maybe invite our commentators.
We have 10 more minutes.
10 more minutes. Okay. Yeah, terrific.
No, but I want to ask you, Beth, about this.
Who's getting interviewed now?
No, I would like to
for sure.
to talk about the issue of the connection with international law and the perspective where you work. That is, how do you see the first of all, the introduction of this model in the global discussion of criminal prosecution and criminal law in the conflict, and the contribution or not of the model to that discussion? How do you see it from the particular and special point of view that you have here?
Yeah, thank you. It's a terrific question, and we've seen, the system of transitional justice, the field of transitional justice, is embedded within a larger system of international law, as you say, that has certain standards for criminal behavior and certain expectations on states to deliver justice. And by justice, we mean criminal justice. We mean criminal penalties to those most responsible for international crimes. And we know that there is a norm that has developed that is against amnesty for international crimes. And so this is the background, very principled set of legal provisions. What you're doing is very bespoke. It's very artisanal in a way for the Colombian community, the Colombian context, and it will be evaluated as against those standards. Now, we've already seen one example of this, and that's with respect to the International Criminal Court. Of course, Colombia is a state party to the International Criminal Court, so jurisdiction existed over crimes that committed on Colombian territory. The ICC prosecutor opened a matter to examine the commission of grave international crimes, certainly war crimes, but also, as you note, crimes against humanity, with the civilian population being the victim of much of the violence. This was not armed groups engaged in violence against each other, with the civilians sort of caught in the crossfires. No, they were deliberately targeted. And the office of the prosecutor exercised his discretion to stay his hand eventually. Now, that was after years, indeed decades, of oversight, if we can call it that, or of working collectively with the Colombian government to say what the expectation was, what was enough for Colombia to do in order for the prosecutor to feel confident that enough was done. This was not a priority. This was not where he should be exercising his discretion or utilizing his very limited prosecutorial resources, because Colombia was doing it well enough. That's the principle of complementarity. It doesn't need to be perfect, complete accountability. This is what we learned from the Colombian matter, but there needs to be enough that the prosecutor feels as if there's no role for him to play here. And so that's ultimately where the prosecutor got and closed the matter. So that's one sort of artifact that we can look to about how international law will accommodate the kinds of compromises that sometimes have to be made in order to bring about peace and have a comprehensive transitional justice approach that maybe won't promise or deliver complete criminal accountability for every single human being that was responsible for the commission of international crimes. The second test, of course, will be the inter-American human rights system, and we have Cindy here who worked very extensively with that system, I know. And so the question is, when they start to evaluate this as one can imagine cases will be brought, potentially by perpetrators, potentially by victims who don't feel like enough justice was delivered. How will the Inter-American Court evaluate this? They have a very advanced jurisprudence on amnesties, but the amnesties that they were evaluating were very blanket amnesties. They were self-imposed amnesties. They were not necessarily negotiated amnesties that had democratic components or that had components that involved justice being more broadly defined, delivering different types of justice, different flavors of justice to survivors. And so there's hints in some of that jurisprudence that they might be more open to looking at more comprehensive amnesties that contain within them some conditionality, that contain within them expectations on perpetrators, and that deliver some measure of justice for survivors, including potentially truth-telling, acknowledgement, reparations, et cetera. So, I mean, this will be something that will be evaluated, I think, for a long time. In my world now, being a representative of our government, we try and capacitate and encourage very broad-based transitional justice responses. I am leading the Office of Global Criminal Justice, so there is an expectation of some forms of criminal accountability, particularly for the Commission of International Crimes and for those deemed most responsible. At the same time, I think we take, as a government, a sophisticated approach to the importance of, as was described in the opening, all of the different pillars of transitional justice. Because, in the old days, we had truth commissions in Latin America, which was a leader in the transitional justice field, as a kind of a consolation prize, because there were these blanket amnesties. You couldn't have criminal accountability. Okay, we'll do truth instead. We now realize that there's enormous value, deontological value of truth, that we need to be investing in truth independently, not just as a consolation prize, but as a value in and of itself. And so I think we're much more sophisticated. And if I could just give a shout out to USIP, we still have in our office Neil Kritz's 3-volume set. It was the first comprehensive approach to transitional justice that was out there. It really framed the field. And so it's why it's so thrilling that you're continuing to host these sorts of events and to advance the dialogue further. So thank you for that. Yeah. Over to you, Lucy.
Thank you so much. It's been an extremely interesting chat. We can stay here forever and just listen to both of you explain Colombia's experience on transitional justice and how international law is trying to adapt and learn from Colombia's experience. So thank you so much. So we will have some brief comments from two also quite distinguished guests that we have. The first one will be Carl Stoffer. Carl is our senior expert on reconciliation here at USIP. Previous to being here at USIP, he was an associate professor at the Center for Justice and Peace Building at the Eastern Mennonite University. While in academia, Carl also functioned as the academic director of the Co-Scholars Program in Switzerland and co-director of the SER Institute of Restorative Justice. Carl has worked in multiple transitional justice processes, including peace accords, community police forums, truth and reconciliation commissions, reparations, and other related subjects. So please, Carl.
Thank you, Lucy, and it's really wonderful to be here, and thank you for each of you who've come out for this important discussion, and thank you so much, Ambassador and Roberto Magistrate. It's really wonderful to have you here again. Let me just make a few comments, and I hope that I can then turn it over quickly to Ana Maria, who will also be giving some response to this. I wanted to start on a sort of personal level. I worked with the South African Truth and Reconciliation Commission, had that privilege, and many places I went afterwards, the question was it a restorative justice process? The late Desmond Tutu, Archbishop Desmond Tutu, referred to it as restorative justice, but restorative justice was just getting its traction at that point, really. And so it was in many ways, it was an add-on to the Truth Commission experience in South Africa, and barely that. I was part of a civilian civil society commission that actually went to the Truth Commission and asked them to give us referrals so that we could bring amnesty applicants and their families or the communities together for these kind of encounters. But that was a rare add-on. We had to write our own proposal and get acceptance from the Truth Commission to do that. And as it turned out, they were overwhelmed with their mandate, and so the referrals were not flowing at the rate we had expected or understood we would get. But that's another story on its own. My point being, when students, when others have asked, was it a restorative justice process? I usually said, no, partially. And then they say, well, what would make it more restorative? And my first answer for many, many years was if we could have required amnesty applicants to actually meet with the communities and the families, obviously those that are willing. We're not going to put people into the under duress to go through this and be re-victimized. And Colombia is doing that with this process. You have incorporated that in an incredibly unique and significant way. And so I want to applaud that. It has taken the transitional justice, I think, to another level. And I think we're going to be watching Colombia like the world watched South Africa. Now, I understand that many people who watch from the outside are starry-eyed and very naive, and that was also the case for South Africa, and the complexity inside the country for those of us working on these issues becomes very difficult. Let me say, secondly, also, we are swimming in the reports and the literature of the human rights movement, and the human rights movement is very, very important. I'm a strong advocate. But in our advocacy and activistic zeal, we continue at times to ask for harsher or longer sentences. And I think we are doing that at our peril without asking to reflect on, are those harsher, longer sentences in fact healing victims? Are they in fact rehabilitating offenders and reintegrating? Are they in fact helping communities move into peace and reconciliation? And this is what we say we're after in this transitional justice exercise. So therefore, I think we have to ask those questions very, very carefully. Unfortunately, history and research, I would argue, from a restorative perspective, does not back up that punishment is the only way in which behavior changes. And so I think restorative justice is stepping into that space, that void, and beginning to say, hey, there are other ways in which human beings are motivated to change their behavior, which of course is one of our pillars to transitional justice globally, and that is non-occurrence. And how do we keep this from, non-reoccurrence? How do we keep the gross human rights violations occurring again? So Colombia, the JEP, is pioneering a historical effort to legally embed RJ into the transitional justice system, and this is unprecedented. The manual that we are looking at today, or have commented on, rolls out a vision, definitions, and applications of this monumental process, and I think it'll be a very important resource for many other contexts and countries who will be looking at the possibility of this war to peace transition being done in a different way. Let me be clear. This requires a paradigm shift. There's no question about that. All of us have been steeped in the punitive, retributive system. And so it does require us to think differently. But it provides a potentially powerful opportunity to answer exactly the questions I just asked in a systematic way, and to hold together victim need for reparations and healing, offender accountability, rehabilitation, reintegration, and community peace and reconciliation. Now, there are challenges for sure, and I'm going to close here soon. The political will is obviously a very large challenge, and it depends on which administration follows any administration as to whether this process will be undermined or buttressed in Colombia. Public perceptions are very critical, and so the efforts at public education and public understanding are going to be absolutely critical. Due process and procedural law. What the JEP is doing with this manual is it's moving the restorative justice process, which they have carefully investigated, to figure out how to place it in line with due and procedural law and protections. And I think that's very important. When we get stressed, when we get frustrated, and the last time I visited Colombia, I said, listen, from my experience, everyone's going to be angry with restorative justice at some point, just like everyone gets angry with the current criminal legal system. But what we do then often is we resort to what we know. And so there's going to be a challenge to keep from going into the litigation creep, as I call it, where everyone sort of pulls back to needing to litigate this whole incredible experiment. And then linking the personal and the structural will be critical, and a collective, and I believe an intergenerational justice needs to be articulated coming out of this. And we may not see the full benefit of this experiment until generations to come. Lastly, probably the most significant challenge, and I'll leave it with this, is the coordination. And I hate to go back to structure and administration, but I think we have to ask that. Amidst the vision, amidst all of the lofty views and plans, we need to think about how is this going to be coordinated. We have the victims centers, we have the territorial reconstruction, and reparations processes, and we have the HEP. How are they talking to each other? How are they designing the strategic communication and coordination so that the people of Colombia and the victims, the civilians who suffered the most from this war, will ultimately feel a comprehensive and balanced justice? Thank you.
Thank you, Carl. Thank you so much for these insightful comments, especially on the challenges of transitional justice in Colombia, which is a new experiment. And well, I would like to present now another special guest, Ana Maria Mondragon. She's an assistant judge to the HEP since 2018. She's a lawyer from the Universidad Javeriana of Bogotá and holds an LLM from Harvard University. She has worked at the Inter-American Court on Human Rights and as an attorney at the Center for Justice and International Law, CEGIL, the Inter-American Association for Environmental Defense, AIDA, and the Independent Accountability Mechanism of the Inter-American Development Bank. Por favor, Ana María, bienvenida.
Muchas gracias. Thank you very much. It's a pleasure to be here and to listen to you. I'm going to provide you with some final remarks, building on 3 points that I think are very important to highlight today. And the first question has to be with what Steve was saying at the beginning. It's like, how do we incorporate the restorative justice principles into the ordinary justice system? But I will add something else, and it's how to make it successful. Because we can add many principles and procedures, but what does it mean for it to be successful? And this is something that we have been reflecting on, and we try to put it on the manual. And the first thing that I have witnessed myself is the transformation of the role of the judge. I think this is very important, because at the end, the judges are giving power to the parties that are participating in the process. The victims, the perpetrators, the communities. And this means, as Beth was saying also, to change the language, to change the performance, to change the questions that they're doing and we're doing, and to name the harm and to name the victims. And this itself, it's reparatory. And this is restorative justice. So I think that we have to take a look very closely to the role of judges and the lessons to the ordinary justice system that we're building in the HEP. The second thing is that, we can have the law, but we need the tools and we need the infrastructure. I think the HEP is a good example for that. Of course, we're judges and we have a lot of lawyers, but we learned that lawyers are not enough. We need interdisciplinary teams. We have a huge executive secretariat. We have mediators, we have anthropologists, we have sociologists, and this requires a lot of budget also and resources from the state, and I think we have to keep that in mind. And we also put that in the manual. So what are the specific tools that we need? And which are the step-by-step that we as lawyers also need to relearn what we learned in the School of Laws, because we didn't learn this actually at law school. The third thing, and I think that the president highlighted it, is the process. We talk a lot about reparations, we talk a lot about restorative sentence, but this is preceded by years of preparation, years of process with these teams. And this process is progressive, and this is actually part of our principles. At the beginning, I remember 6 years ago, we were thinking, okay, we have victims and perpetrators, and we're going to put them on a room to have this face-to-face. And the question was, no, wait, we cannot do this. This could be harmful for them. How do we prepare this encounter? Because at the end, and this is the outcome that we're starting to see, a transitional restorative process has an outcome that it's very human, and this is measured by human transformations. We're seeing the transformations in the perpetrators, in our defendants, and in the victims, and these individual transformations are going to be the key for the social and broader transformations. So as Carl also was saying, how can we measure this? We also have a chapter on the manual on this, like trying to build these indicators. This has been very difficult for us because we will need to wait for years to measure if this is successful or not. But of course, the issue of reincorporation, it's all the time present. The issue of non-recurrence, the issue of healing trauma. We're starting to talk more about healing. How can restorative justice contribute to the healing of individuals and a society? So this is like our first point. Second thing that I would like to highlight is the issue of restorative sentences and the co-creating of the remedy that Ambassador Manshak was mentioning. And the question here for us was, okay, what's the contribution of the JEP to the integral reparation standard of international law? Because the JEP is only one part, only one institution as part of the judiciary, but we have to work together with other institutions that are in charge of integral reparation of the state. So what's our role on that? And of course, we are opening the door for accessing transitional justice. This is very important, but during the process, we're providing truth, we're providing acknowledgement as measures of satisfaction, and this is a standard of integral reparation. And also, these TOARs, which are the works that the perpetrators will do in terms of not repairing, but contributing to reparation. This is only one part that has to be combined with the other measures of the state, and this is where these projects come as a laboratory of reconciliation and reparation. And what we have seen, for example, with demining, with environmental restoration, with the building of communitary infrastructure, is that these works themselves constitute measures of restitution, of rehabilitation, of satisfaction. So we're building together the puzzle of integral reparation in order to comply with these international standards from Inter-American system of human rights, but also in terms of effective and adequate sanction. And then as a conclusion, and here we would like to open the conversation also to the public, is, okay, which are our challenges in terms of communication, social communication, because this is a change of paradigm of justice from a retributive justice approach to a restorative justice approach. And this change of paradigm doesn't happen in our hearing rooms. This has to go to the public, this has to go to the Colombian society. And we have been reflecting also a lot on how to communicate this. This is very hard. This is very technical also. So we're building these communication strategies with our communications team, also with these international dialogues, and then with the international bodies in terms of positive complementarity in a constructive way. Today we're going to have a meeting with the Inter-American Commission. President will go to the Inter-American Court. We have an agreement with the ICC. So here is where we have to put our brains together and try also to see how to change also and to adapt the standards from an ordinary justice perspective to a restorative justice perspective. Thank you.
Gracias, Ana Maria. So finally, we'll open for questions and answers and comments from the public. I will gather, for timing purposes, I have to apologize. I will gather around 4 questions we'll do a first round if that's okay, and then you can answer back. So we'll have, if you can state name and organization, please. Cindy?
Thanks so much. This has been a wonderful event. I really appreciate everybody who's spoken and all their comments, and the organizers, so thank you. My name is Cindy Arnson. I'm a Distinguished Fellow at the Wilson Center. I have two questions, but I think, I'll put them out there. The first relates to this issue of disappointment. You mentioned that there are 9 million, I think Beth mentioned that there are 9 million people now registered as victims in the system that the JEP has put together. How do you deal with the fact that you can only take on certain emblematic cases and can't deal with the entire universe? And how do you prevent, people from feeling just massively disillusioned, given the huge universe of victimization in Colombia? And the second goes back to a very initial criticism that was made of the JEP, which is that there are members of the military, for example, that have been condemned and are serving sentences as part of the ordinary justice system, prosecuted for crimes by the Fiscalia, that are not eligible or that somehow are not going to be eligible for the alternative sentencing and transitional justice mechanisms that the JEP is providing. So how have you dealt with that perception that there's an inherent unfairness in the system?
Thank you, Cindy. Jimena?
Hi, Jimena Sanchez from WOVA. So I have a question for Magistrate Vidal. In terms of the differentiated approach, the ethnic chapter very much acknowledges all of the impact of the legacy of the slavery, of colonialism, and then you have in the Truth Commission report a very concerted effort to integrate that as part of the crimes that were committed. So when you're looking at restorative justice in those communities, how do you deal with the fact that you have this accumulation of issues that also contributed not just to those crimes, but I'm sure you're probably getting from the victims the need to deal with a lot of those structural problems as well. So how do you limit that, or how do you work with that?
Thank you. Anybody else?
Thank you. So my name is Sahil Lalji. I'm a member of Global Criminal Justice and Ambassador Von Schacht's office. As someone sort of coming new to the space, I found it extremely profound just to hear about the Colombia case and how it's really focused on humanizing both the victims but also the perpetrators. And I think that gets to a very sort of like deep-rooted understanding of how do we transform not only societies, but also inwardly hearts. When you can transform hearts, you can transform minds and society. And so I think this really gets to like a deeper sort of essence of the work that people are doing here. And so I'm kind of wondering, in what ways can you institutionalize, but also continue that work so that society collectively can continue working on this? So when I think of that, whether it be religious institutions, community healers, right? Whether it be through indigenous means or also through other sort of spiritual practices. And so I'm wondering, to what extent are the sort of local cultural and community practices also being incorporated into the healing? Because I think a lot of this requires a level of decentralizing and giving that to the locals to figure out. And so I'm sort of wondering, what ways can you build that, and what ways can you create sort of larger spaces within societies for that healing to continue across generations?
Thank you. I think we had another question over there.
Hi, thank you. My name is Leslie Wingender. I'm with Humanity United. It's really an honor to be here and to hear more about the work that's going on. I wanted to pick up on the mention of administration or logistics operations. So much of the theme that's coming up in the JEP, and what's been amazing is the openness and the process of transformation within the JEP as lawyers, moving more towards the restorative practices and exploring that with communities. How are you connecting already with other organizations and partners that have in Colombia that have been doing that with the Truth Commission, for example? Like how do you think about partnership with organizations and others as you're embracing restorative practices so that we're not repeating again? I think there's a lot there already in Colombia. Just wondering, like, what are the challenges to that and what are opportunities you might see? Thank you.
Okay, thank you.
You start, Rebecca. Sorry. Let me take the top.
Well, thank you for your questions. Interesting for us. First of all, the questions of Cindy about this disappointment of victims. We have to understand the kind of contribution that we do that is limited, structurally limited. And we work with concepts like prioritization. We don't work with all the crimes of the conflict. We have the possibility to prioritize and to construct these macro cases, only 11 macro cases for 50 years of conflict. It is a extraordinary prioritization with a difficult political decision, not only for what we are going to investigate, but what we are not to investigate, and to justify it to communities. And that's one of the reasons why it is only possible in the context of a restorative project of participation of victims. Only if we have this dialogue with victims, they can understand why we took a decision on that or another way. And we have a charge of explaining the decisions to the communities. And in the side of the situation of military, we are very accurate and with the treatment of the parts of the conflict. One of the contributions of the model of the tribunal is that we investigate both parts of the conflict, not only the guerrilla, but the army too. And in the agreement, it is there are norms that establish what the agreement called this symmetry in the treatment. In fact, the situation of military, we are processing 4,500 military. All of them were processed before by the ordinary justice and were subjected to sanctions of 50 or 40 years of prison. And with the creation of our tribunal, they attend the investigation out of prison. They obtain a conditional liberty from the tribunal. We offer them and to the guerrilla legal representation. It is very important. Legal and independent representation for attend the process. And they have the same kind of sanctions that the guerrilla has in terms of time, in terms of projects. And at the moment, they are working together. organizations of former military and organizations of former guerrilla members working together in the projects. And it is very interesting because the commitment of militaries with the process is huge, and it is a very good new for the tribunal, this relationship, very strong and close relationship with military, that find a way of integration to the process. Well, respect to Jimena, it's of course there are communities as the African, Colombian communities that accumulate discrimination and history, but the same happens to peasants, the same happen to women. And it is the origin of the particular and criteria of intervention that we're trying to make a balance or to give them some possibilities that allow to that communities to work with that discrimination and to offer some intervention of the state. But it is clear that the effect of the conflict is especially hard with that communities. And it is a challenge for not only for the peace process, but for the Colombian democracy in the future to deal with that situation. And respect to the third questions, and it is the healing. Maybe who can make a better answer is Ana Maria, that is working a lot in issues of healing. But we need to work, as you said, with the religious communities. We have worked a lot with indigenous communities, and the traditional comprehension that they have of the restorative processes, especially the possibility to talk, for example, with lots of people, to take judiciary decisions between 3,000 people talking for 1 week. They are very familiar with that kind of processes. And they teach a lot us to the ways of deal with the issue, not only the punishment, that is the criminal problem, but the issue of healing, that is the problem of peace. And it is very interesting, this field of work, and we know that we can work on that. And I want to mention especially my colleagues. One of the assets of the tribunal, of the contributions to, is that we have indigenous magistrates, the indigenous lawyers with a lot of experience. Some of them are religious authorities in their communities, at the same time are magistrates, and they have contributed to the comprehension of the work that we do. This is a strong contribution. And finally, a subject that you suggest that is and you too, is the problem of administration and organization. And we had to innovate. It was difficult. And we created something that we call the restorative system, that it is an agreement between the judiciary, the tribunal, and the institution of the executive branch for working together in the projects in the restorative projects. Because this, I want to say, restorative justice is much more expensive than the retributive justice. Restorative project is much more slow and complex than a prison. But the contribution is bigger too, to the issue and the goal of reconciliation. And it needs a lot of institutional coordination, a lot of resources, internal and international, and many contributions from technical support from different experiences.
Maybe I'll just add a few bits to an extremely comprehensive response to really great questions. So the first is just to emphasize the communications challenges here. And it really is about strategic communications and managing expectations. And even as I say that, it sounds very instrumental, and I don't mean it that way. It really is about people understanding what the system can deliver, why it has been designed the way it has been designed, why certain compromises have been made, and what it hopes to achieve in terms of these larger goals of rehabilitation of the society, a democratic future, et cetera. And being able to speak to the different segments of Colombian society and of the international community, right, who have somewhat of a say in this, including our own Congress, the international institutions that will ultimately be looking at these decisions that are being made, et cetera. And so having a strategy for engaging in this continual communication and also just touching communities and letting them provide feedback and a willingness to adjust based upon that feedback. And I think that's something that the system has done. It's also a huge, to Jimena's point, coordination problem. There's a lot of institutions doing transitional justice here. We still have the justice and peace approach with the paramilitaries, the Truth Commission that you mentioned. Not to say what's going to happen to ELN and the FARC dissident groups. Are they going to be entitled to their own system of some sort? They rejected the current system, and so should they be integrated into the JEP? Should they be entitled to that when they walked away from it at the first and now suddenly they come back and want something? It's extremely complicated and will have to be a sort of whole of government approach. The idea of Cindy's point about emblematic cases and your description very clear of the macro cases and why that approach was chosen, I can say that in my work, I use that example quite a bit because I work in areas where the crime base is enormous. It will be impossible to deliver justice, and so we can't set that up as the goal. So the question is, can this emblematic approach help here? And so I'm just back from the Gambia and Liberia. Both now are embarking upon a transitional justice process for decades of war, and in the Gambia's case, repression. And they're both considering this idea of emblematic cases as a sort of symbolic approach to say this type of abuse happened. This is what it was about. This was why it happened. But there's deep, potentially due process concerns there. Why that defendant and not some other when you can't prosecute everyone? So all of these societies are grappling with this. And then just to follow on a point that Carl made about, and your point about you can't impose reconciliation, the idea of creating space for communities to come together and see what happens organically is incredibly important. And I can recommend the film Long Night's Journey into Day. You're probably in there somewhere if we look carefully, because it covers many of the Truth Commission, the TRC hearings. But one of the vignettes, there's 4 vignettes, does describe just a space that was created for the mothers of young men who'd been killed and the perpetrator who'd been he was actually a black South African, but had been a part of the police who had targeted these young activists. And you could just see the shifting and the decisions of these mothers. Were they going to forgive this young man or not? I won't give it away, but the point is that would never have happened but for the creation of a space that allowed it. And I'm sure there are many outcomes that were very different, and ultimately that's owned by the survivors themselves. They can decide whether they want to pardon or to reconcile or to forgive, but at least you get to comprehension, which is your point, a better understanding of the impact of violence on the perpetrator and their family and community, and then the survivor, their family and their community.
We ran out of time. Thank you so much, everybody, for coming. And I think we leave with a very thorough and comprehensive understanding of the transitional justice process in Colombia. So thank you very much. Thank you, Ana Maria, and thank you, Carl.